spiraling tale of the ongoing Article 146 process involving the Chief Justice, Her Ladyship Gertrude Esaaba Torkornoo. That's taken yet another twist this evening, where the minority is calling on President John Mahama and the Attorney General, Dr. Dominic Ayeni, to address the concerns as raised by the suspended Chief Justice regarding her ongoing impeachment proceedings. During a press conference Wednesday, June 25, Justice Torkornoo accused the process of constitutional violations, procedural breaches, and infringement on her fundamental human rights. She described the investigation into the 3 petitions for her removal as flawed and alleged that the proceedings were skewed to ensure her removal. Let's take you back to Wednesday and hear from Madam Gertrude Esaaba Torkornoo, her ladyship, I should say, make the allegations for herself.
There is no one person in this country who can look at me in the eye and accuse me of taking a bribe to decide a case. This is the personal treasure of integrity that I live with. So what if these current proceedings are being carefully staged to result in my removal as Chief Justice, even if there's no lawful justification?
And that's Gertrude Esaaba Torkornoo. Apologies for the quality of sound there. We're just going to try and rectify that and bring to you really the argument she put forth on the date of June 25, exactly what case she made, and amongst many other things, her arguments that the procedure was not in line. Let's try and one more time listen to Her Ladyship Gertrude Esaaba Torkornoo.
When all Article 1, in this case, because they have permitted of a Chief Justice.
Well then, challenges with the audio quality, but let's bring you back to the conversation involving the minority. Now, we know that despite these allegations, the government's Minister for Communications, Felix Kwakye Ofosu, dismissed her claims as far-fetched and reaffirmed the government's commitment to due process. But the minority insists a direct response from the President or the Attorney General is necessary. Now, listen to the Member of Parliament from Manchester South and ranking member on the Constitutional, Legal and Parliamentary Affairs Committee, Nana J. Bafo, who are raising these issues in Parliament early today.
No matter what we think of the Chief Justice, it is for situations like this that the 1992 Constitution was promulgated. It was to prevent abuses of this nature. Clearly, it is an unfortunate situation that the very head of our justice administration is having to go through this. I do not care about the guilt or innocence of her. What is important is that she should have at her disposal everything necessary to defend herself. She has to have it. And in the absence of it, I think that the whole process has been undermined. In the absence of it, the process lacks integrity. That for me is key. And I think that the Attorney General should be speaking to these matters. I think that the President, very respectfully, who has taken an oath to defend and protect the Constitution of this country, including the fundamental human rights, should be worried and should be concerned that under the guise of the secrecy of the process, the Chief Justice is having to go through this. It is an unfortunate situation, and I think that the whole nation should be concerned. I think the other issues that she raised, in my humble opinion, as important as they may be, they are not as primary as the issue of the notice of the prima facie determination. There's a historical antecedent to this. You all know that in time past, when the prima facie determination has been made, presidents have made all of us know, right, the basis for which they arrived that there was no prima facie case. In complaints or petitions that were made against Justice Enini Abua, complaints or petitions that were made against Justice Georgina Wood, in complaints or petitions that were made against Justice Sophia Kufu. Even when there had been a determination that there was no prima facie case, there had been a detailed opinion from the President as to why he thinks that there is no prima facie determination. If for nothing, we should be guided by that precedent. If for nothing, we should be guided by that precedent. And in law, there's an obligation to give a reason for a position. At the very least, if the president says that he's not ready to provide a reason for that decision, right, it is important. It's the fundamental human right. It's a basic right of the Chief Justice for her to know the case or the parts of the complaint which the president considers that she has a case to answer. That is a basic principle of law.
And that's the Member of Parliament for Manchia South and ranking member on the Constitutional, Legal and Parliamentary Affairs Committee, Nana J. Bafwe, who I want to bring in right now, Kwekwansa Sarah. He is a lawyer and a trainer of lawyers currently. Also is a former director of the Ghana School of Law, joining us this evening on phone. Thank you very much, sir, for speaking to us this evening.
Thank you for having me on your show.
Mr. Ansasari, I want to just hold you briefly because we're just citing for ourselves this evening as well a statement as issued by one of the petitioners, Daniel Ofori, where he's seeking to respond to that June 25 press conference by the suspended Chief Justice. And I'll just read that, then I come to you for us to begin this conversation. And it reads verbatim that my attention has been drawn to a media engagement on the 25th of June 2025 by the suspended Chief Justice, at which he publicly discussed the content of my petition for her removal as Chief Justice and the proceedings in respect of the petition. Now, the Chief Justice is acting, according to him, in clear breach of the provisions of the 1992 Constitution of the Republic of Ghana, which require the inquiry to be in camera. As a law-abiding citizen and out of the respect for the constitutional process and the committee, I will not seek to go on the path of the suspended Chief Justice, not even to correct plain falsehoods in her statement. When it is constitutionally and legally appropriate to engage the public on matters regarding my petition and the process, I shall do so. Truth stands with an exclamation mark and signed Daniel Ofori. Never-ending twist, really, what it is that we're seeing. But Mr. Ansasari, I just want to bring you in on this part, even before I get into the arguments being made by the minority. We're seeing responses already come through to that addressed by the Chief Justice on Wednesday. Does this latest one come to you as a surprise that Mr. Ofori is being forced somewhat to come out and respond in a certain manner to the claims by the Chief Justice?
Well, it's not, I'm not surprised. But what Daniel Ofori has said is the right thing to do. He is saying that the appropriate time is when the whole nation has been informed of the outcome of the proceedings. That, I think, should be the right approach. As far as he is concerned, he's not going to respond. And I think I'm in total agreement with him. I associate myself, with the sentiments that he has expressed.
But it's not a position respected by the minority. I say this when they are making a case strongly out of the many things they've been saying this evening that the president should have made known the basis for coming into the conclusion that there is a prima facie case against the Attorney General. That's one of the many arguments they are making this evening, even as they also push forcefully for a response from him.
Well, the argument that the CJ has not been apprised, of what went and in to constitute a prima facie determination is neither here nor there. Once she has submitted herself, to the committee, he has waived or might be deemed to have waived, any such protestations. If he had them, he should have made them, to the committee at the first appearance that I have come not to lend any credence to your assuming jurisdiction, but merely to protest, give protestations to you, and that I'm not participating until all the requirements have been fulfilled. Once she submitted herself to the adjudication, she deemed to have been supplied with whatever she needed, in order to make her appearance before the committee. So it's too late now, to be alleging breaches. By endorsing, by accepting the petition from the president and actually responding, she must be deemed to have been supplied with what she needed, to be able to make a response.
But counsel, being deemed to have been supplied is different when she's appearing before the committee, because she's making clear arguments that she's not been provided with the specific petitions or area points to which she's expected to answer for when she goes before the committee. I believe you heard her as well when she says that, for instance, the approach that's been taken by the committee is an adversarial litigation one, yet still she doesn't know the specific allegations she's expected to be responding to, raising concerns as well about breach of natural justice. Surely there must be a medium for her to be able to air these grievances and have them corrected, because everybody deserves a fair hearing.
Well, the head of the meetings, I think you would have left this thing, to be expressed by a non-lawyer. I think the Chief Justice, he knows, the rules of procedure. And if there have been lacuna or lapses in the rules of procedure, and nevertheless, she submitted herself, to the jurisdiction of the committee. Why is she complaining? But you know what? Aside all that, we must commend the Chief Justice for her boldness in drawing attention to the ills within the justice delivery system. And for the first time, the Chief Justice of the Republic is informing or advising the general citizenry that our justice delivery system is sick. It is ailing and needs, emergency medication. I think we should commend her. For the first time, the ordinary litigants, must, go out, bold, tested, and be smiling that all the things they have been saying about the justice delivery system have been acknowledged by the Chief Justice herself. The Chief Justice is alleging, allegations of violations, of the law, violations of fundamental, principles and rules, violations of, the Constitution here and there. These are the sort of complaints, litigants to the court have been making, and each time, such allegations are made, they are swept under the carpet as being, the rantings of disgruntled, litigants. Now he is aggrieved. She now understands, what a grievance is, and what constitutes, a grievance. She is now a beneficiary of the broken system. So it is good the Chief Justice herself is acknowledging. So on her own showing and admitting, our justice delivery system is sick. It's sick and needs an emergency surgical operation.
Right.
How to go about it must be left to the CJ herself and the able lieutenants, the judiciary.
And
so I'm glad that she has, drawn our attention to it.
Right, I'll come to you on what it is that we can begin to do to repair this ailing judicial system, and also ask the question about whether or not this does not do further harm to the perception of the judiciary. But on that specific demand by the minority that the president or the attorney general must be responding directly to these claims or concerns as raised by the Chief Justice, where do you stand on this?
It is utterly misconceived, utterly misplaced. The president owes no duty whatsoever. In fact, if I were the president, I'll just ask my minister in charge of government communications to respond and tell them that the president, is very busy and already firmly committed with affairs of state. And therefore, the president thanks them. The president has, taken notice, but, will not make any comment. That should be, the stance of the president or the attorney general. I've heard you, but I'm not going to make any comment.
How concerning?
And it is Prez to tell them that let us all respect the, removal process. Let us have confidence in it. The Chief Justice, is, on trial in accordance with the Constitution, and the Chief Justice knows and has absolute trust in the justice delivery system. So when all, is said and done, then the president will address the nation, on whatever, has been associated with it. That must be the president's response.
Ms. Ansah, hold the line for me. I want to bring in Mustafa Gbande. He's a Deputy Director of Operations at the Presidency as well, the Deputy General Secretary of the NDC, who's also, unfortunately, is not on the telephone line with us. So let me just come to you in concluding that. So yes, the president should not be paying heed to these calls by the minority, but they are making them nonetheless. Does it surprise you that the minority, understanding fully well the processes currently that have been instituted, are making this demand?
Well, I'm not surprised. The minority is behaving like a wounded tiger. The MPP is still licking its wounds. It hasn't recovered, from the shock, that it received. And it has become a party of disorder and dismemberment. The MPP in 1992 was, a party, comprising able men and women who had absolute confidence, in the system of governance,
right.
Had absolute, confidence in everything. They had, the likes of DJ Darocha, Itala JT, Obeiskai, and the Dombo, Jato Kaleo, and CK Sedam. Today, most of the people at the helm of affairs are jokers. And the NDP seems to me to be leaderless. And anybody, that struggles to find an able leader to lead them, will do what the minority is doing. They have become lawless, they have become unruly, they have become orderly, and always trying to plunge the whole nation into chaos. If I were the minority, we would just, go back to do, our homework and restore confidence in our supporters, and try to rediscover, past glory, rather than what they are doing. What they are doing now, will not advance, their political cause, any more than what they suffered, at the hands of the NDC at the last poll. December 8, 2024, was a general underperformance for the MPP. Let us hope that they will learn their lessons, do the right thing, stop the ugly noises, and chew the path, of law and order. Instead of this unruly behavior they are demonstrating to the general public.
Right. Finally, on that question I asked about whether or not all of this that continues to play out does not do more harm to the judiciary than good, how do we begin to even try to attempt repairing all of this and fixing the ailing judiciary, as you have alluded to?
You know what? Chief Justice Torkornoo, in an attempt to expose the enemy of rule of law, has rather brought out who the enemy of the rule of law is. It is the judiciary itself. Let us wake up and try to mend the broken fence.
Thank you very much, Mr. Ansasa. That's Kwekwan Sasare. He's a lawyer and a trainer of lawyers as well, former director of the Ghana School of Law, speaking to us this evening. I mentioned we're going to engage as well the Deputy Director of Operations at the Presidency, as well as the Deputy General Secretary of the NDC, Mustafa Gbande, is going to join us on the phone pretty shortly. But let's hear again the arguments as was put forth by the minority, many of which have been quickly dismissed by Mr. Ansasare, who's been speaking to us this evening, strongly describing the NPP as leaderless.
She has to have it. And in the absence of it, I think that the whole process has been undermined. In the absence of it, the process lacks integrity. That for me is key. And I think that the Attorney General should be speaking to these matters. I think that the President, very respectfully, who has taken an oath to defend and protect the Constitution of this country, including the fundamental human rights, should be worried and should be concerned that under the guise of the secrecy of the process, the Chief Justice is having to go through this. It is an unfortunate situation, and I think that the whole nation should be concerned. I think the other issues that she raised, in my humble opinion, as important as they may be, they are not as primary as the issue of the notice of the prima facie determination. There's a historical antecedent to this. You all know that in time past, when the prima facie determination has been made, presidents have made all of us know, right, the basis for which they arrived that there was no prima facie case. In complaints or petitions that were made against Justice Enimi Abua, complaints or petitions that were made against Justice Georgina Wood, in complaints or petitions that were made against Justice Sophia Kufu. Even when there had been a determination that there was no prima facie case, there had been a detailed opinion from the President as to why he thinks that there is no prima facie determination. If for nothing, we should be guided by that precedent. If for nothing, we should be guided by that precedent. And in law, there's an obligation to give a reason for a position. At the very least, if the President says that he's not ready to provide a reason for that decision, right, it is important. It's the fundamental human right. It's a basic right of the Chief Justice for her to know the case or the parts of the complaint which the President considers that she has a case to answer. That is a basic principle of law.
Right, that's Nana Bafwe Jewa, who's the Member of Parliament from Insha South as well, the ranking member on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. I want to read just a comment that's come through via Facebook, our live stream on Facebook. I mentioned you're a part of the conversation for us this evening as we bring you these stories. This one from Edward Dugbaza. He says the committee refused to give the CJ the charges which amounted to prima facie. If not, her lawyer should ask for it. That's a comment from Edward Dugbaza, who's following the bulletin on Facebook. Do well to do same there as well. But Mustafa Gbande is joining us right now on the telephone lines. I mentioned he's the Deputy General Secretary of the NDC as well as the Deputy Director of Operations at the Presidency. Mr. Gbande, thank you very much and for your patience as well, holding the line and joining us this evening. The NPP minority wants you to do one thing, or wants the President to do one thing: respond directly to the allegations by the Chief Justice. They say they are not pleased with that press statement by the Minister for Government Communications. Hence, they want either the President himself or the Attorney General to be responding.
Well, because they have categorically mentioned the President, I believe that the senior minister designate for communications will appropriately consult to the Presidency and respond to that. But my personal view is that what the minority as a political group
got to do with a matter or an adjudicating committee, law for that matter. A Chief Justice have been attending and appearing before this committee. So the ordinary thing who
Mr. Bande, I apologize, but you have to reposition for us as the connection to you is suffering a number of noise. I can hear you, but there's continues to be screeches that doesn't allow you to hear properly the submission. Let's try one more time. You were making the case that they do not understand properly what is happening.
Well, it's a deliberate infliction of ignorance by the minority too, and also a continuation of their attempt to politicize the matter and the removal of the Chief Justice. And I also think that the Chief Justice herself will go down in history as one of the propagandists the worst Chief Justice Ghana have ever experienced. Because fundamentally, the posturing, the commentaries as I heard the Chief Justice read yesterday, I was very sad for students of law and judiciary. Which Chief Justice go to organize a press conference? Even in the press conference, students of law are not following her, judges are not following her, but an MPP parliamentary candidate is the one giving her solidarity. And you want to believe that these Chief Justice are doing propaganda with her to predicament. Even if fundamentally there is nothing the matters before the committee. The Chief Justice is publicly misconducting herself, and she knows that. She knows what she's doing is not just offensive, but what she's doing is not lawful. It's judicial misconduct by a judicial officer who is trying to be in contempt of the processes she's before. The people, the number of Ghanaians who have gone to court and have lost cases, do they go to organize press conferences? How many people have gone to court and lost cases between these same Chief Justice, but yet they have had to go to their houses and cry alone? Yes, she is appearing before a committee. Even before the committee finished hearing, you have dumped the boat and you are complaining outside. Even a Chief Justice does not understand basic law that when your rights are violated, you can only find remedy in the court of law and not a public opinion.
But she's done that. She's asked her lawyers to seek a review of these right breaches at the High Court, and so she's done that. But she feels the need to make the Ghanaian aware.
Do we have to open the Pandora box where every Ghanaian a case in the judiciary should go and open a press conference to explain their issues? Is that what the law says? So clearly, her press conference was again motivated by the influence of Apenyoma, supported by himself, his influence in Parliament. And that is how come this Chief Justice is going on the path of self-destruction because she listens to an unwise counsel from Apenyoma, influenced negatively in the direction that would destroy herself. I find it very unfortunate, and I'm dumbfounded that a Chief Justice is caught in this level of mad of deliberately demonstrating public ignorance of the law as a Chief Justice of Ghana and wanting to spread that mad on anybody. Why do you invite the president into this? Invite the president into this.
Right. Let's try and wrap this up quickly. She has stated quite clearly that she believes this is a cooked political ploy to have her removed from office. Yes, the Minister for Government Communications has responded to this, but that tag is going to stick. This is going to be in the minds of Ghanaians that the NDC has plotted to remove the Chief Justice and is only carrying out that ploy. That's the claim she's made, and I'm sure it's one that I'm sure you've heard on the streets right now following her press conference.
Well, which tag is not a tag. I don't think that anybody is in a hurry cut by the Chief Justice. The important thing is that if she is wrong,
Mr. Bande, are you still with us?
Was awarding contracts to her daughter. Was it Mustafa that influenced her? Didn't you know that it was wrong?
But these matters are not before the committee.
Because she commented in public when the Chief Justice was taking double rent living in a government bungalow and taking 20%.
Mr. Gbande, unfortunately, the line is back again, not allowing us to hear your submission. If we could kindly reposition or have my producers phone you again, then we can wrap this up quickly. But we're speaking to the Deputy General Secretary of the NPP, the Deputy General Secretary of the Governing National Democratic Congress, Mustafa Gbande. We're going to call him back on the telephone lines quickly, just so we can finish this conversation. He's also, as well, the Deputy Director of Operations at the Presidency. Just to round up this conversation, because there's a lot more we're bringing to you here on Hot Edition. We're looking or talking the subject of Galamsey as well, because there's been a huge operation in the Western region resulting in the arrest of a number of individuals, the seizure of excavators and the likes, and we'll get you details of that. But we're trying just to wrap up this conversation quickly with Mustafa Gbande. Then we'll bring that to you. This is Hot Edition here on 3FM 92.7. 24 minutes to the top of the hour here on 3FM 92.7. Remember, we're streaming live on Facebook. A number of you have sent your comments through. We're going to be reading that to you as well. This one from Mohammed Musa says, the NPP members in Parliament are acting lawless. And that's according to Mohammed Musa. Then there's a lengthy one as well from Mahamadou Fusheni Ayigbedo. He says that the actions of the suspended Chief Justice appear to suggest a potential affiliation with the NPP, given their apparent support for her actions yesterday. Regardless of her party affiliation, she, along with others involved, must be thoroughly investigated and held accountable if found guilty. The President and the Attorney General should not interfere in the matter at hand. Furthermore, it is unbecoming of the Chief Justice to engage in such conduct, and she should refrain from doing so. She should allow the law to work. And that's another comment from Mahamadou Fusheni Ayigbedo. This is Hot Edition. Unfortunately, we've not been able to reconnect with Mustafa Gbande, but we can bring you some more stories right now. 22 minutes to the top of the hour. Let's go straight to the Western region right now.